Good morning. I'm now opening our hearing in the oral argument, or we're going to have oral argument today on an objection to and a motion to dismiss the first amended accusations against Tesla Incorporated. There are two accusations, one against Tesla in its capacity as a vehicle manufacturer, which has Department of Motor Vehicles case number 21-02188. That motor vehicle manufacturer license number is 63277. There's a number here as well that I don't know what it means, but perhaps I will learn. AIMS number 21V1L12011. And the last number I'm going to recite is Office of Administrative Hearings has given that matter our case number 2023-110-194. The vehicle manufacturer matter is consolidated with an all but identical matter involving Tesla in its capacity as a vehicle dealer. That case is DMV case number 21-02189. The license number for the vehicle dealer is 68106. There is this same AIMS number, and the OAH case number for that matter is 2023-110-196. I am Administrative Law Judge Juliet Cox from the California Office of Administrative Hearings, and I have been assigned to hear this matter for the Department of Motor Vehicles. What I'd like to start with today is to have counsel introduce themselves for the record. You have provided some documents in support of Tesla's motion to dismiss this matter, and I have read those. So then after you've introduced yourselves, I'll hear some oral argument. I may have some questions for counsel, and then I will prepare at the end a written ruling on my motion. I may or may not tell you at the end of the hearing where I'm going with it, but ultimately you'll receive a written order. So let's start by having counsel introduce themselves, and I'll invite counsel for the complainant to introduce himself first, please.
Good morning, Judge Cox. My name is Greg Call. I'm from the Office of the Attorney General here on behalf of the Department of Motor Vehicles.
Good morning. And for the respondent.
Good morning, Your Honor. Joel Kurtzberg from Cahill, Gordon, Rindell on behalf of Tesla.
Good morning, Your Honor. Ariel Newman from Berg Morella on behalf of Tesla.
Good morning, Your Honor. Mary Gold from Berg Morella on behalf of Tesla.
All right. Good morning to all of you. Now, as I mentioned, I have received and read the documents that you provided. So I've seen the first amended accusations. I have seen Tesla's objections to those accusations and motion to dismiss. The department filed an opposition to that motion, and I received also a reply from Tesla. And I've read those, so I do not need y'all to just repeat what they say. However, our opportunity here is for you to expand upon anything that is particularly important. As I mentioned, I may have some questions for you. If you don't volunteer the questions that I've made some notes about, I'll ask them of you. But at any rate, I would like to invite Tesla to speak first, since it's the respondent's motion. Which of you should I be listening to the closest?
Well, two of us. I'll start. Mr. Kurtzberg will handle the constitutional issues. I'll handle the other issues.
All right.
So I think what probably makes sense from our perspective, at least, unless Your Honor wants us to start somewhere else, is just briefly address what I think of as the procedural objection that has been raised by the DMV. So to be clear, what we're asking you to do, Your Honor, is find as a matter of law that the accusations don't state acts or omissions upon which the agency may proceed, dismiss the accusation, and then recommend that the DMV dismiss the proceedings and not refile. There's been this objection raised as to whether you may do that, whether you may even hear this motion. And to clarify, I think it's important to distinguish between the cases that the DMV cited and what the law actually is. So we have put before you three cases, I think, that really laid it out pretty clearly. The Manning case, which states that an objection under the government code that we are filing under, which is 11506A2, an objection under that code may be raised at any time during the pendency of the proceedings before the hearing officer. Marlowe, which states that the notice of defense, which we have filed, performs the office of an answer and demur. I think it's important to note that they included demur. One of the things that the notice of defense does, because that's a challenge to the accusations, not simply a response. And then the Monroe case, which basically says that Tesla is entitled to have the objections ruled upon prior to or at the hearing. So with those three cases, there really shouldn't be any question that Your Honor can rule on these objections and should do so, and I think Tesla's entitled to that. There's the three cases that I think of that the DMV really cites, O'Mara, Frost, and Kramer, deal with a different situation. They deal with the situation essentially for a motion for a non-suit or demur to the evidence. Basically, after the complainant in that case put forward their evidence, the respondent said, hey, you haven't put on a prima facie case, dismiss it. The court said you can't do that. And the court in Frost really explained why that is. And it's basically because it's going to be very inefficient. No procedure laid out for it. What is, they sort of discuss, right? What is the hearing officer supposed to do? Sort of summarize the evidence that has come in by that point, pause the proceedings, ask the parties to comment on that summary of evidence. It's sort of this very inefficient procedure. Whereas here, what we're talking about is prior to anything really happening in the case, the only thing that's happened so far is 2 years ago, there were accusations filed. And then now 6 months ago, months ago or so, the amended accusations filed. So those cases really are a very different situation than.
Wouldn't it be even more inefficient though for me? Let's say that I dismissed the first amended accusations as you request and remanded the matter or made a recommendation to the department that it not refiled, that there's nothing to say here. And they didn't adopt that recommendation and said, no, we're going to file a second amended accusations and we're going to send it back to the Office of Administrative Hearings because we want these people to put on their evidence. I mean, unless a superior court judge told them that they could not do that, wouldn't we wind up with an even more convoluted and inefficient matter than if the hearing is open and I hear all of the complainant's evidence and respondent says, I'm not putting anything on because I don't think they met their burden. In that situation, I can most definitely agree with respondent if the evidence comes out that way.
Though at that point, we would have a whole hearing on accusations that are deficient from our perspective.
Right.
And yeah, there's two reasons I think we need to have a ruling now as opposed to later. One is very practical and one is very legal. So on the practical side, this is not, as I understand it, a sort of typical case that is brought before by the DMV. What I understand from the DMV counsel that I worked with before the Attorney General stepped in is isn't really a precedent for this kind of case. And I've understood that from opposing counsel now as well. And this is going to be complex. The discovery that has been requested by the other side is voluminous. The discovery we've requested is voluminous, right? There's going to be hard fought litigation is what I would say. And then there's going to be a full hearing. And so we're going to be dealing with a lot of work by Your Honor, by the parties, that if you agree with us on our position on the objection, really is for nothing. Because if you agree that they don't basically state a claim, then why are we going through it? If they go back, they want to file an amended objection, we'll do, amended accusation, we'll deal with that if and when that happens. But there's also a very stark constitutional issue that I think Mr. Kurtzberg should address. That's another reason why you should hear it now and make a decision now before a hearing.
Yes, Your Honor. The other thing about all of the cases that have been discussed on the procedural point is that they are not First Amendment cases. The fact that Tesla has raised its objections in part based on First Amendment rights being chilled here or violated here suggests very strongly that you need to consider the objection at the earliest possible time. There is very substantial case law to this effect in both federal courts and in state courts that we've cited. The Ninth Circuit case that's most on point is Green versus Miss United States of America. In that case, the court said, quote, the federal courts have emphasized the importance of resolving First Amendment cases at the earliest possible juncture. What's the reason for that? It's obvious. There is a chilling effect on speech just by the fact of the kind of burdensome litigation that Mr. Newman outlined. And for that reason, both federal courts and state courts, in state courts, we cited the In Re Tobacco Cases 2 decision, which was a 2004 decision. And the state courts have essentially adopted the same rationale that the federal courts had. So it is a problem for the litigation to proceed if in fact we have a meritorious objection, which we think we do. And the doctrine under the First Amendment is so important that courts have even discarded the doctrine of constitutional avoidance. Normally, when there are constitutional questions and then there are other questions, you try to address other questions and avoid addressing constitutional questions. But when the First Amendment is involved, because of the principles that I just outlined, courts have said, you don't even do that. You need to get to the First Amendment questions first. And so none of the cases that have been highlighted, basically, even on either side, come close to suggesting when an objection is raised on First Amendment grounds, that you shouldn't address that first. And there are reasons why you should.
Let me ask you a question about that, though. Given that this is a matter that alleges that the way that Tesla has essentially advertised or described its vehicles in commerce is misleading and unlawful. I mean, it's not a matter of just saying these are awesome cars. It's a matter of saying that they have full self-driving capability, for example. And how could I resolve? I understand your First Amendment concerns, but is the context of the speech not critical, the factual context for resolving those First Amendment claims? And then if the factual context is important for that, then how could I resolve them without having a hearing in which, I mean, I understand from your moving papers what Tesla has given at least a preview of how it intends to contextualize the statements, but there may be a different context that the department wishes to rely on that will be more fully elaborated after an evidentiary hearing. How would you address that question?
Okay, so I would address it. There are many pieces that I would say. It's a very complicated question.
Objection is a compound question.
Yes,
Fair. Right.
but I know I'm happy to address all aspects of it. First of all, we believe that the accusations are limited to the specific 4 items that they have identified, and that it would be very problematic for them to require us to not even know what statements we are looking at. And in answer to your question about whether the context matters, of course, we submit very much that the First Amendment requires the context matters, and that one of the problems with the accusations themselves is that they try to make arguments that take these out of context. We also believe that the case law supports that when you look at the context of the 4 statements or the 4 specific things that they identify in the objections, it is clear that no reasonable consumer could conclude that the statements that are made or the labels that are used suggest that these are fully autonomous vehicles. When you look at them in context, in fact, these statements are surrounded by disclosures that are so ubiquitous. They are literally everywhere, from the very moment that someone goes to Tesla's website, wherever it is, wherever these terms are discussed or the statements are found, when they use what's called the Tesla configurator. That is, you have to buy your car online. You have to, if you add these features, there are disclosures there. The owner's manual has numerous disclosures. The car itself has disclosures that appear, and if you are not putting your hands on the vehicle, they also alert the driver. We submit, Your Honor, that when looked at in context, these are so ubiquitous, and that is one of the main First Amendment problems with these accusations. It's the accusations that are actually misleading, in the sense that they try to cherry pick statements and take them out of context. And that when you look at them in context, it is so clear that these are so surrounded by statements that make clear that these are not fully autonomous vehicles, that these are features that assist drivers, that require active driver supervision and don't make the vehicle autonomous. With your honor's permission, I'd be happy to go through and show how what they alleged takes things out of context, and that in fact, we think that it is so clear that because of the First Amendment issues that are raised, that you need to rule now, and should rule now, because you could conclude that even based on the specifics they provide, we can't be playing a game of whack-a-mole where we they say, well, we only listed 4, but that's what they argue in their papers, but we could actually argue that any statement, even though we haven't disclosed it to you, is misleading, we haven't given you the context, we haven't given you the statement, that would not give us the notice that we need to defend ourselves. We can't just have them looking for new statements in discovery. That's not how litigation should work either. But if you look at their discovery requests, that's precisely what they are proposing, and it's precisely what you should not allow. When you look at those specific statements, we suggest that these disclosures are so ubiquitous that it is crystal clear that it is said so many times that these features do not make the vehicle autonomous. Happy to walk through that if Your Honor would like me to.
I think your documents, your submissions do that for me, and I will take a look. Actually, I should ask you a question about that also, but you did provide a number of materials to give me that context from your client's perspective. So I'll take a look at those. I did have one question, and one of the things that you provided for me was a request that I take judicial notice of certain things. And some of those things were selections from Tesla's websites addressing the allegation that these phrases that are perhaps misleading appear in written marketing materials, primarily on Tesla's internet website. So you provided those, and you also provided several items that were court records. Let me ask Mr. Call, actually, I know you may not be finished, but I'll ask Mr. Call while I'm thinking about this question. Is the department have any objection to my taking judicial notice of those items?
We do, we certainly do.
Then if so, I'll invite you to explain more when we get, don't let me forget to invite you to explain more about that, but did you have something else you wish to say about the reasons that I should evaluate this? The constitutional reasons that I should evaluate this claims early?
I don't have more to say on that point, although I am happy to address the judicial notice point.
Yes, you do.
I do think that, first of all, there is no question that when you look at the legal standard for judicial notice, that the things that we requested that you take judicial notice of are judicially noticeable. The warnings on the website, it can't really be disputed that they are what they are. The warnings that are in the vehicle itself, or the owner's manuals, or all these things, we're not providing those for the truth of the matter. That is to say, none of them, we are not providing them and saying this definitively proves that in fact, the vehicle is not a self-driving, fully autonomous vehicle. In fact, they concede that that is part of their case, that it is not. The statements, I think they would concede are true, but we don't offer them for that purpose. We offer them for the purpose that they provide the context in which the statements that they provide in their accusations, the specific statements that are at issue, to provide the full context in which those are viewed by consumers. One cannot dispute that those disclosures are what they are. There are cases that say that things like websites are judicially noticeable, or pages on a particular website. And because we're not offering them for the truth of the matter, we think there is no real dispute that you can take into account that those disclosures are out there, they exist. We can debate the legal significance of what those disclosures, you should conclude from those disclosures or not conclude from those disclosures. But one can't dispute that the disclosures are there. The problem with the way they have pled the accusations and the way they are arguing in their brief is that they are trying to take these statements that they provide, the 4 specific statements, which they then try to say, and we can say anything else along the way if we decide on the fly that there's some additional misleading statement, we're going to tell you what it is as we litigate, which would not be fair and would violate due process. It would not give us notice of the allegations against us. But they try and take those statements out of context, and that's problematic. But on the point that you asked specifically about, we think that the First Amendment requires you, unlike, there are no cases that have been cited to your honor about this procedural issue that are in the First Amendment context.
Can I just add a point, Your Honor, sorry, on the RJN, the request for judicial notice specifically. You know, the accusations reference disclaimers, and what we have put in, the key documents that we put in, obviously it's a lot that we put in the RJN, but the key stuff are those quote unquote disclaimers, as they term them, that are thus incorporated by reference. So this, we term it as an RJN. I'm not even sure that's, you know, really right. I mean, they raised it as a disclaimer in the accusations. We're putting the disclaimers before the court so you can see the context of what's happening here. Yeah, it's really right on point with the 4 statements that they have put in the accusations. They say there's disclaimers. They say as to one of them, hey, that's not enough. We say here's all of them.
Okay. All right. Anything else that you'd like to say to support your motion before I hear from Mr. Carl?
Well, I mean, I'd like to talk just a bit about the failure, sort of what I think of as the failure to state a claim under the statutes, but I don't know, before we move to that, I don't know if you have anything else on the First Amendment issues or not.
Well, I only would like to add that the protections that are provided to commercial speech are very rigorous. They've been described as rigorous by both the Supreme Court. They've been described as rigorous by the Ninth Circuit. The Ninth Circuit has said that government prohibitions of truthful commercial messages are particularly dangerous and deserve rigorous review. There is a test that is an intermediate scrutiny test that we have provided under the Central Hudson case that is rigorously applied. And it is applied in cases where even the speech at issue is what the case law calls potentially misleading. That is, if it's potentially misleading, if it can be worded in a way with additional information, disclosures, whatever else it might be, that's not misleading, it gets full protection under that intermediate scrutiny test under the First Amendment. The only way that it does not get First Amendment protection is if it is what is called inherently misleading speech. In their briefing, they pivot and they try to suggest that something in their briefing, they try to suggest that this is inherently misleading speech. And I just want to urge the court, I don't think they appreciate just how high the bar is for something to be inherently misleading under the First Amendment. The cases that we've cited, for example, make clear that even advertising that has been considered very misleading, like cigarette companies saying we have low tar cigarettes, which misleads consumers, that is not inherently misleading. It has to be, and the burden of proof under the First Amendment is on them. That's another thing in their briefing. They say, for us to win, we would have to show, and they list all these things. That's not how it works under the First Amendment. They have to make a showing because the First Amendment is implicated. That burden of proof is they have to allege, and they haven't alleged it, and they would have to show that no matter how many, there is no disclaimer, there is no disclosure, no information that would ever make a consumer not be misled by this speech. They don't allege that, nor could they allege that. And if that is the burden of proof that they want to proceed on in this case, we think that as a matter of law, it's very clear from all of the disclosures that we've provided that they can't meet that burden. It's just no way as a matter of law that there is zero way that any of this information can be presented so that, for example, when it says autopilot and the disclosure says current autopilot features require active driver supervision and do not make the vehicle autonomous, they have to argue and show that in fact, consumers that see the term autopilot next to disclosures that say this requires active driver supervision and do not make the vehicle autonomous, would still conclude that this is a fully autonomous vehicle that does not require active driver supervision. And I think that as a matter of law, they cannot do that.
I think it's also bouncing off of that is, what do they allege in the accusations? They allege that somebody might be misled, and I want to say might, because that sort of mere possibility is not permissible under the statutes. And that allegation in and of itself indicates that the accusations are deficient, but they might be misled to think that the vehicles are autonomous. Now, autonomous under the California code has a specific meaning and a specific definition. We put that in the request for judicial notice as well. That refers to the Society for Automotive Engineers. They have a table, the two key features that turn a car that has, we think of as sort of advanced driving capability that even might be able to drive itself, but that turns it into something that's autonomous, is that you don't need to supervise it. You can literally put your feet up, don't have to pay attention and not do anything. You don't have to be ready to take over without warning. Well, that's big. And so when you look at these advertisements, and as Mr. Gertzberg says, full self-driving capability, and I have them printed out if it would be helpful to hand to you.
Yeah, that's all right, 'cause you
So
provided.
figure two in our brief, you know, that's from the configurator when you buy it on the website.
But what about the possibility that a person might be misled to think that their vehicle very shortly with an over-the-air update will become fully self-driving?
But that's
That's
different.
not this case, Your
Okay.
Honor. That's not what they've alleged.
Okay,
And what they have alleged is that these terms are misleading and that one would conclude that it is fully autonomous now. And by the way, it's full self-driving capability. That last word is actually very, very important because it makes clear that the car has the capability to be, to engage in full self-driving. And the disclosures make clear that that means in the future. I think one of the actual, I think it's figure 9 in our brief, which we could put up. I know you've asked us not to put them up, but I'm happy to aid the court and tell you, but you know, the disclosures are very clear that it says all new Tesla cars have the hardware needed in the future for full self-driving in almost all circumstances. And they say the future use of these features without supervision is dependent on, and they go on to say a number of things. So the capability is there, and it makes clear that as the technology advances, there will be over-the-air software updates, and that the ability or the capability will expand as time goes on. But it also makes clear that it is not currently full ability to be a fully autonomous vehicle as defined under the law. And so the advertising is crystal clear that this is not something that is fully autonomous. And the disclosures that we've provided make that very, very clear. And they are ubiquitous. They are everywhere. They are on the website, in the configurator, in the car itself when you activate the feature. If you're not doing it, you get buzzing and you get signals that say you have to be actively supervising. It has to be a reasonable consumer that would conclude, and we would submit that this, with all of these disclosures, there's just no way that a reasonable consumer could conclude that essentially what they're trying to show is that exactly what Tesla says is not the case. Tesla says that these features do not make the vehicle fully autonomous, and they require driver assistance and supervision. And yet, we think no reasonable consumer, a reasonable consumer looking at all that could conclude that the disclosures don't say what they say repeatedly.
So just a couple more points. I
Yes.
think in our brief, in our initial opening brief on page 30, we set out a couple of cases that talk about that sort of future looking statement and why that's not actionable here. So I point, Your Honor, to those for the example you gave. And as Mr. Kurtzberg said, sort of going into the statutes, so moving away from the First Amendment issue, but moving towards the statutes and why, even if you were to get past First Amendment issues, you shouldn't, but even if you do, we think they have problems, excuse me, with how they framed the accusations here for some of the reasons I said. But I don't think there's any dispute to the point Mr. Kurtzberg raised between the parties that it has to be the reasonable consumer. Both parties have talked about that. But so what does the reasonable consumer mean? We have put before your honor, in every case, essentially, that talks about reasonable consumer looks at something in context. They don't read something out of context. They don't read it to ignore language that's right around it. And
I just want to interject on that for 2 seconds, but it's not surprising that the statutes have been interpreted that way, because if they weren't, they would violate the First Amendment. It is actually required under the First Amendment and the statute. Sorry.
no, that's fine.
Please continue, Mr. New. And don't forget that although we're recording this matter, if someone ever did want to make a transcript, they would have a really hard time doing that if more than one person is speaking at a time. If we had a live reporter here, that person would be admonishing you about that. Instead, we'll just go with me.
Consider myself admonished, and I will let Mr. Newman proceed.
I think, look, the example that we put in the brief is the Simpson v. Kroger case, the butter, what I think of as the butter case, where somebody says, hey, look, it says spreadable butter. And underneath it, it says with canola oil or with olive oil, right? That's very similar to what is going on here. If you were to conclude, let's say, which we disagree, that autopilot might mean autonomous, if right under autonomous, it says this does not make the vehicle autonomous, which it does in every of the 4 places that they have raised in their accusation. It's the exact same situation. You can't ignore that. That's not reasonable. That's not a reasonable way to read the advertisement. And so, you know, the DMV then puts in a couple of cases and said, well, look, here are cases where courts found that you could, based on the label, find that it was misleading. And that's fine. That doesn't hurt our case, because in all of those cases, the courts look at the entirety of the label and they conclude that even taking that into account, is misleading. So for instance, the 1 a day case that they put in front of the court says, if you look at, they literally put the entirety of the label into the case. In Westlaw, you pull it up, it has the pictures there. And on the back, after 1 a day, it says, take 2. All right, that you can understand why that was misleading, right? But the principle that's at stake is what we're talking about, which is you got to look at the advertising in context. You, as a matter of law, can and must look at it in context in order to rule on this. They have a few cases where that doesn't happen. All of those are not upon California. They're out of circuit. This is the Novartis case, the Brown Auto Stabilizer, Warner Lambert, Abbott Labs. Each of those comes from Third Circuit, FTC case, 7th Circuit. These aren't really relevant here. And so where does that take us? It takes us to the point really that Mr. Kurtzberg has made, which is that when you look at these in context, no reasonable consumer could reach another conclusion. A couple of points just about the DMV's arguments, and then I'll turn it over. We talked about the burden that they try to flip, which is inappropriate, both as to the First Amendment, but also on the statutes at issue. They raise this idea that the disclaimers raise a question of fact. I think Your Honor raised that question in one of the questions you made. The reality is all these cases that we have cited demonstrate that the court can and should look at these questions, at these labels, excuse me, and can determine as a matter of law. There really is no dispute here about what the advertising says. We have 4 statements. This is what it says. We put it in front of the court. They don't say that's not what it says. They just don't want you to look at it. But there's no question of fact as to what these advertisements are. And so there's no question of fact that needs to be decided. There's also no allegation of actual consumer confusion in their accusations, which is a big problem when you think about it from the statutory side of things. They just don't allege that. They allege, again, the mere possibility, which is not permissible. They allege that they argue that the brand name alone may be misleading. We've explained, and this really does go back to the constitutional point. You can't just look at it by itself. You have to look at it in context. And then the last point, which came up earlier, but I do want to make sure we touch on, is this idea, well, maybe it's not actually just those 4 statements. Maybe it's a lot more statements. And this really is a problem in terms of how we're gonna handle this case. Because in their opposition at 12, page 12 of their opposition, they argue, look, we have told them about the statements, we've told them the date, we've told them the location, but they have notice. They set out 3-4 cases where it holds that notice is required, a specific notice that allows us to prepare our defense and so on. And then 3 pages later, they say, well, actually, the accusations involve wherever and whenever these terms are used by the respondents and their agents. And if we think about that, when you're talking about a company like Tesla, which has thousands of agents, what is this case going to look like if that's what this is? If that's really what the accusations are, I don't think that's what they are. I think that's trying to save them in light of the full context of the advertisements. But if that's really what they are, we don't have notice. And so now we go into a different problem and a different reason that the accusations need to be dismissed. I mean, when you just think about it from a practical perspective, it's not just sort of what are we going to be dealing with in advance of the hearing? What are we going to be dealing with at the hearing? And is Tesla suddenly on the hook under these statutes because some salesperson somewhere in another state even made a statement or didn't make a full statement about something and somebody was, I mean, that really takes us down a path that doesn't work for litigation. It causes problems under the government or the administrative hearing practice 3.8 about fair notice, which they cited and the cases. So from our perspective, either this is a case about these 4 statements in which the context is clear as a matter of law, or we have a problem on notice, they got to go try again because these accusations failed to provide notice.
The fact that the accusation, you referred to, a salesperson, for example, the accusation does describe the 4 allegedly misleading statements or phrases as appearing in written marketing materials, primarily, which is a qualifying word, but primarily on Tesla's internet website. But it does say written marketing materials. So I hear you that if everything that anybody purporting to speak for Tesla said in any context about the vehicles could be an issue in this hearing, that scope would be wildly broad and impossible to contain. But if you limit it to written marketing materials, why is that not a clear enough notice if they're written marketing materials that the respondent has prepared?
Because I don't know what written marketing materials mean in this context. They talk about the website specifically. That's what they actually say. Written marketing materials, I can pull up the language.
It says written marketing materials primarily on Tesla's internet website.
Right, so, okay, and when, right? If it goes beyond that, when?
There's some dates specified here as well. So
Exactly, the
there's
dates that are specified there,
Right.
right? But that's not where they're going on page 15 of their opposition,
Okay.
which where I'm quoting, whenever or wherever those are used by a respondent or its agent. And does it include the website? Does it include something that, I mean, there's not a lot of written marketing materials, but there are, there's Twitter, there's all kinds of stuff out there, right? In this day and age, what does it mean? What are we talking about? And when we actually come, we don't think we should ever get there. But if we ever do come to the point where we have a hearing, what are we defending against? Because obviously this is not meant to be a surprise to anybody, and that sort of broad interpretation, taking it beyond the website on those dates, leaves it wide open and leaves them the ability to literally pivot in the middle of the hearing if they feel like they need to some other statement that we haven't talked about. So I think from a fair notice perspective under the cases that they cite, this is something they brought up, not us. It can't be left open. It needs to be, here are the statements we're all talking about. They've done that. In the accusation said, these dates, this website, these things.
And we, in the motion for judicial notice, Your Honor, have provided what's on the website, which is referred to in the accusations, all of the disclosures during the periods that they're talking about. And we think that it's clear from all of those disclosures that as a matter of law, no reasonable consumer could conclude that this is misleading when it says full self-driving capability, and right under it, it says in figure 10, for example, the currently enabled features require active driver supervision and do not make the vehicle autonomous. And that when it says autopilot, There is a similar disclosure. On figure 6 that we provided, current autopilot features require active driver supervision and do not make the vehicle autonomous. It is all over all of the website materials during that time period. And we think that it's clear as a matter of law in light of all those disclosures.
One of the things that may be interesting if we do end up holding a hearing in this case, of course, is that you've provided static web pages here as part of your request for judicial notice that a person can read. But one of the important features in communication via a website or a video game or anything else that's interactive, of course, can be the order in which people see different things or what you have to do or request to make this or that information come to you as the consumer. So if that type of information about how the pages link to one another and how the user experiences then turns out to be important, we'll have to figure out some way to understand that, but
I think the problem of sort of even considering that now is that there's really no dispute that this is what the advertising is.
Right.
And so they sort of offhandedly said, well, some of these you have to scroll to see.
Mhm.
First of all, it's not correct, but even if it is, just say figure 2, which is the full self-driving where you're going to order it.
Mhm.
If you have to scroll, you have to scroll before you can add it and buy for $12,000. Remember, somebody's paying $12,000. Probably then a reasonable consumer, probably going to read this one paragraph, which says requires active supervision and doesn't make the vehicle autonomous. So I don't think right now, even thinking about this motion, we need to worry about that because there's really no dispute about what the ads are.
There may or may not be any dispute about what the pages say, and I may be able to understand it well enough based on that information. I'm just kind
Yeah.
of thinking ahead to how the overall communication might work. And I haven't ever had a case in which that type of dynamic communication turned out to be an issue.
I
So,
think if we get there, I think
Yeah.
we'll see it's clear, but I'm hoping we don't.
all right.
We would, one last word, then we'll pass the baton, but we would submit though that the materials that we provided show that the warnings are so ubiquitous that that question can be answered right now. I mean,
Okay.
at least 65 times there are warnings in Tesla's owner's manuals about this that make this about as crystal clear as it can be made clear. There are so many instances across the website for the time period that we're talking about that it was too numerous for us to literally list all of them and provide them to your honor. They are throughout the use of the features themselves. When you turn the vehicle on to set it up, turn on the feature, when you continue to use the feature, it is so ubiquitous that we think that it just doesn't need to, you don't need to ask those questions because it's clear as a matter of law.
All right, thank you. Mr. Call, what do you have to say in response to what we've just heard? They've discussed a number of things, and I'll let you organize your remarks however you think makes the most sense, although I may have some questions for you as well.
Okay, there's a lot. I've organized it kind of similarly to the brief and hopefully I can present in the order that the overarching order, and then I can bounce off and reply to some of opposing counsel's comments. The DMV filed the accusations because Tesla has engaged in blatant false advertising of the autopilot and full self-driving capability features on its vehicles. Tesla's advertising and the names of the features themselves exaggerate the capabilities of its automation features. Now, Tesla admits that its cars are not fully autonomous and do not fully drive themselves, yet they continue to advertise to consumers that their cars have autopilot and full self-driving capability. These actions violate state laws and regulations on advertising automated vehicle features. Tesla's advertising and the names of the features themselves may cause consumers to receive vehicles and features that do not perform as expected and may contribute to those consumers operating Tesla vehicles in an unsafe manner. This is not novel. Various regulators, our legislature, various commentators have pointed out that the names of these features and their advertising around these features are misleading. You'll read a newspaper article will say Tesla's full self-driving, which is not full self-driving. is going to be now $99 a month, right? Everyone, there's a lot of acknowledgement that what they call full self-driving is not full self-driving, and I don't think there's a dispute about that. Tesla has now objected to the accusations and requests dismissal of this entire matter. As we've discussed under the Administrative Procedures Act, we believe that the relief that they seek, which is full dismissal of the case, is not warranted. And even recommending a dismissal of the case at this juncture is not warranted. We've talked a little bit, and you've mentioned the efficiency issues that underlie the APA. Those are squarely at issue here. The Frost and Kramer cases talk directly about this, that the point of APA is to do efficient hearings, to not have people running back and forth to the agency, to have agency get its board together, make decisions, considering the recommendations of the ALJ. It's a wasteful process. We should just proceed to the merits. That's what the APA was designed to do, to promptly get us to hearing, to get to the merits, not to fight over the pleadings. Tesla has not cited any provision of the APA authorizing ALJ to dismiss a case or to propose to an agency to dismiss a case on a pleadings motion prior to a merits hearing. Tesla, in fact, has not cited a single case where an ALJ actually dismissed an accusation or proposed to an agency to dismiss an accusation prior to a hearing based on a pleading motion. They've cited these two cases, Rolfe v. Monroe and Manning v. Watson. In neither case, in neither of those cases is a pleading motion resulted in a dismissal by an ALJ. The Manning case does say that such a motion can be brought to a hearing officer, but it doesn't say it needs to be heard and decided before the merits hearing. Similarly, Rolfe Monroe is a little bit more helpful to them in the sense that it does say that, oh, maybe a better practice here would have been for the hearing officer to hear these, but it doesn't say that respondent is entitled to a ruling on a pleadings motion prior to a merits hearing. As such, the outcome Tesla requests here appears to be completely unprecedented. If not rejected outright, Tesla's motion should be simply taken under submission to be decided at the same time in concurrence with the motion on the merits. The hearing on the merits, excuse me. So moving forward to the motion itself. Under the APA, I want to back up and just get back to what the pleading standards are here in an administrative proceeding, right? Under Government Code 11503, these are the pleading standards. The accusation need only, quote, set forth in ordinary and concise language the acts or omissions with which the respondent is charged. To that end, that respondent will be able to prepare their defense. That's it. There's no requirement that facts be pled with particularity, and they've cited a lot of cases, these labeling cases where Rule 9b applies in federal court, where facts must be pleaded with particularity, or where the Iqbal Twombly pleading standards come in about that has to be plausible, the claims must be plausible on their face. None of those apply in an APA matter. All that is required is fair notice. And then if an accusation doesn't meet that standard of providing fair notice, the result is not dismissal, it's amend the pleading to add more things. We think there's not enough here for them to know what this case is about, so add a little bit more. And we're happy to do that if Your Honor thinks that there isn't fair notice. There certainly is fair notice here. We allege specific statements, claims, feature names, and the statutes that have been violated. There's been some talk about what the allegations are, so let me just pivot to that real quick. The paragraph 5 in each of the amended accusations talks about Tesla's advertising of ADAS features in written marketing materials, primarily on Tesla's internet website, using the product labels and descriptions. Right, so paragraph 5 has examples of the misleading statements that are on the websites and in written marketing materials. But I think Tesla's trying to get you to ignore paragraph 6 of the amended accusations. Paragraph 6 says, respondent continued to use the product labels autopilot and full self-driving from January 1, 2023, which is the date that Vehicle Code 240.11.5 came into effect. From that date to the present, and at least on these two dates, and those labels describe partial driving automation features using language that implies or would otherwise lead a reasonable person to believe that the features allow the vehicle to function as an autonomous vehicle. Respondent thereby violated 240.11.5B. In other words, the website, the accusations about the website are one thing, but we also have a law that we are enforcing here. The legislature passed a law saying that vehicle manufacturers should not name or describe partial driving automation features in language that makes a consumer think that it's fully automated, or in language that implies that it's fully automated, right? So the DMV is enforcing that law, that you cannot name or describe features. Apart from what's on the website, it's the names of the features themselves that are at issue. If Tesla didn't have a website at all, we would still have a problem with the names of the features, because the legislature said it's now illegal to name your features in the way that Tesla has named them. And DMV is trying to enforce that law. Let me move to.
And that's a law, paragraph 6, specifically a statute that went into effect on January 1, 2023.
Correct.
Is that why? So the suggestion that using these names for these features, these vehicle aspects before January 2023 might have been misleading, but as of January 2023, it's also specifically in your argument statutorily prohibited.
Yeah, we think it was misleading and improper under other laws before, but once 240.11.5 came into effect, now we have a new basis of why the actual, not just the advertising, the written advertising is a problem, but Tesla's actual decision to name the product, what it's named it, that is now illegal. The legislature says you can't do that, and we're trying to enforce that. So you can't just point to, well, here's what the website says, and here's all the disclaimers on the website, no violation. It's actually the actual names of the product themselves, which are at issue here, and that we'll be pursuing at the hearing.
Okay, please continue.
Yeah, so let me address briefly some of the constitutional points that have been raised by Mr. Kurtzberg. Of course, Tesla's opening brief said that the first reason that the accusation must be dismissed is because this vehicle code section 240.11.5 is facially unconstitutional. Tesla spent 4 pages in its opening brief pursuing this line of argument. In its reply, however, it now concedes that an APA proceeding is not a proper venue for challenging the facial constitutionality of a state law. As I said, the reply brief makes that concession, then it also basically ignores 240.11.5. The reply brief never once cites to 240.11.5. In a sense, hoping to wish it out of existence, right? We can't do that. We have a law, the legislature's passed a law, the DMV is required to enforce the law, and that's what it's doing in this proceeding. Contrary to Tesla's argument, the DMV is not seeking to belatedly expand the accusations to cover the feature labels more broadly. These were there in the amended proceedings, as I've said, in paragraph 6. So speaking more to Mr. Kurtzberg's argument, the attempt to hide behind the First Amendment should be rejected. First of all, there was some statement here about the urgency of addressing these matters upfront, the constitutional matters upfront, due to the chilling effect that litigation could have on commercial speech. The California Supreme Court in Caskey, which is a case Tesla themselves cite, talks about this. They talk about that commercial speech is actually a little bit different, and we don't have to worry about the chilling effect. They say, Supreme Court said in Caskey, commercial speech is hardier than non-commercial speech in the sense that the commercial speakers, because they act from a profit motive, are less likely to experience a chilling effect from speech regulation. So that just undermines this whole idea that we have to rush in and quickly address this constitutional issue because we're worried about chilled speech. The California Supreme Court says when you have commercial speech, you're less worried about chilling speech because speakers are speaking from a profit motive, which is what we have here. Now, even if this court did reach the constitutional issue, which we don't think they should, but even if we did here, it's well settled that there is no constitutional right to run false advertising, false commercial advertising. The Supreme Court has been very clear, misleading advertising may be prohibited entirely. The DMV here is alleging that Tesla violated false advertising statutes in section 240.11.5. These laws are not at all like laws that that might ban potentially non-misleading speech, right? The touchstone cases here are where the court says where they overruled like laws prohibiting all advertising of pharmaceuticals or prohibiting all advertising of lawyer services. And the court says, hey, you're doing more than just prohibiting false speech here. You may be prohibiting some non-false speech here. And so we're going to give constitutional scrutiny to that. But these laws that we're proceeding on, they apply only to false or misleading commercial speech, which has no protection under the Constitution. Whether or not Tesla's speech was in fact false or misleading is to be resolved at the hearing, not on a pleadings motion. Now, going back to Mr. Newman's point now about kind of the demurrer-like motion of failure to state a claim. Even if Tesla's motion was treated as a demurrer in a civil court, which it shouldn't be because that's not what the APA provides for. But even if it were, the accusations would still not be subject to dismissal. Courts have consistently said that demurrers are inappropriate in false advertising cases because whether a practice is deceptive is a question of fact, which requires consideration and weighing of the evidence from both sides. Here, Tesla has submitted cherry-picked various disclaimers on various pages of its website, which they say establishes as a matter of law that no reasonable consumer could be misled. We've heard that several times this morning. But the disclaimers themselves need to be interpreted. They need to be understood. They need to have context. At the hearing, Tesla will have to show that these disclaimers were viewed and understood by consumers sufficient to overcome the deceptive names of the features. On the other hand, we will put on evidence showing, for example, that despite the disclaimers elsewhere on its website, this is just an example, Tesla has published a video that shows a Tesla vehicle navigating public roads without the driver ever touching the steering wheel, and with a caption at the beginning of the video that says, the person in the driver's seat is only there for legal reasons. He is not doing anything. The car is driving itself. This is context. This is context for the disclosures and the disclaimers that we don't have, that's not before you. And it shouldn't be before you on a pleadings motion. What should be before you on the pleadings motion are the pleadings, right? We haven't put our evidence in yet. How does a consumer understand the disclaimers on one website when another Tesla website includes a video like that? This is a factual issue, again, that can't be decided on the pleadings. We will need evidence about how many Tesla users and Tesla buyers even review the website and its disclaimers. If I buy a Tesla and loan it to my son to go out for the evening, does Tesla require that he reviews all the disclaimers in their request for judicial notice before he uses the autopilot and self-driving features? I didn't see anything in what has been submitted that shows what people see in the car or what people see on the app. We only have what's seen on the website. If I buy the car and I see all the disclaimers and understand completely what full self-driving means, because I went through the configurator, and then I get sick of my Tesla in 2 years, and my neighbor across the street offers to buy it, and he pays me, $20,000 cash for it. What does he see? Does he go on the website first? Do we have evidence that he goes on the website first to see what full self-driving means? Right? We don't know. The secondary market, we can't control that, right?
I
So
did see some news just the other day suggesting that Hertz is trying to unload a whole bunch of Teslas because people didn't want to rent them, I guess. They're still, when you go to rent a car, they're still really pushing you to rent a gas vehicle and nobody wants, it's actually kind of hard
That
to
might be a
rent.
different issue.
Yeah.
Yeah.
But anyway, but it does illustrate the secondary market that they're selling these cars to people who may not have ever gone through the
But those
configurators.
people seeing the advertising that
That's
is
a-
alleged to the accusation. That's the
That's a
basic
question.
problem with this
Yeah.
argument.
Okay, fair enough. Go ahead.
But again, it's the names of the features is what the legislature says. Don't name your features something that implies full self-driving if it's not full self-driving. And that's because the legislature recognizes this is a problem. That drivers are thinking they have a car with more automation than they actually have. And obviously we haven't put any evidence on this and it's not appropriate in a pleadings motion, but there is a lot of discussion about the accidents that have been caused as a result of this, right? And there's arbitrations going on and there's cases all over the country about this issue itself. And the DMV here is just at the initial stages of filing the accusation saying that, hey, the legislature says you can't name your feature this, and you have named your feature this, right? And that's, if you just look at the case from that perspective, the disclosures on the website are not particularly relevant to that. And even if they are relevant to what a consumer saw when the consumer went on the website, right? They require interpretation, they require context, which you can't get in what they put in on a request for judicial notice. We understand that full self-driving can now be purchased through the car's dashboard interface or on the Tesla app. No, we have no discussion about what disclosures are there. What has Tesla's CEO said about full self-driving, and how does that impact a reasonable consumer's understanding? If you get disclosures on a website and then you get a tweet that says, ignore what's on the website, these cars drive themselves. I'm not saying that is an actual tweet, but I'm saying, for example, then we have a problem, right? We need to understand the context of these disclosures and how these products are portrayed. These issues cannot be resolved on the pleadings and Tesla's proffer of its website disclaimers. These are all factual issues for a merit hearing. I want to make a couple more points that they brought up. There was a mention about, this. I think one of Tesla's arguments is going to be, well, these are very expensive products and these are sophisticated consumers. So of course they're going to read carefully the owner's manual before purchasing these things. I think that's not something that this body should assume on a pleadings motion, first of all. Second of all, I happened to hear an announcement recently that Tesla's, you can now subscribe to Tesla's full self-driving features for $99 a month, which undermines this idea that, oh, this is a very expensive $15,000 product that people are going to do extensive research on. We don't have that. We need a merits hearing, we need discovery and a merits hearing to really flesh out these issues. We can't just use Tesla's cherry-picked screenshots to show that no reasonable consumer would be deceived. Similarly, this idea of the future-looking statements, that's an issue of fact. When a statement is your car will drive itself, whether that means it will drive itself after you buy it or will drive itself in some undetermined point in the future, that's a question of fact. It can't be resolved on the pleadings. We need to have a hearing on that. And again, I think I've kind of circled around to it, but let me just specifically say we do oppose the request for judicial notice. These are matters that are in dispute. The interpretation of the disclaimers is in dispute. We don't dispute that their pictures of the website are accurate. What we dispute is what they mean, how a reasonable consumer would understand them, and how they should be interpreted in the full context of all of the messages that Tesla is giving out, including the very names of the products themselves.
So do I take it that you object to my taking judicial notice of there are 11 specific items that they've identified, I believe. And your objection is as to all of them?
Yeah, I don't think any of them are matters that are not subject to dispute.
Okay, I will evaluate that request then in light of those remarks.
Yeah, I want to talk a little bit. It seems like a lot of the cases we have on false advertising are about food cases and about labels. And we should keep in mind the vast difference we have here between the food labeling cases, which courts they've gotten so many of them, they've built up all these ways to dispose of them early. And that does involve the court sometimes taking judicial notice of a butter label or a one-a-day vitamin label and saying, oh, you know what, you flip it over and it tells you the truth, or you flip it over and that's not enough, it doesn't tell you the truth, right? But this is not a case where it's a butter label, right? This is a case where the legislature has said you cannot name your feature X, right? And now the DMV is here saying Tesla has named this feature X, right? And we need to have a hearing on that to understand that. Their constitutional issues can be fully fleshed out at the hearing, but it can't be resolved on a pleading motion. I do think even if you do look at, even if you ignore the 24011.5 allegations, if you're just looking at the false advertising allegations and how the disclaimers overcome the misrepresentations in the names of the labels, it is more like the one-a-day vitamins that is actually take two, right? This is full self-driving, hashtag not full self-driving, right? We've seen it's a bit of a moving target. We've gone from full self-driving to full self-driving capability, but as a footnote, it's not always called capability. Sometimes it's just called full self-driving, right? And now we've even seen them adding a new term, supervised full self-driving, right? So we've got a moving target here on actually what it is. But the key language and the language that perked up the legislature's ears and caused the legislature to pass a law prohibiting people from naming their products in a way that's misleading is full self-driving and autopilot. And that's all throughout the legislative history of 24011.5. In sum, this body should deny Tesla's motion or take it under submission so that this proceeding may move forward to a hearing on the merits. To the extent this body is somehow concerned that the accusations don't give proper notice, we request the opportunity to promptly amend them.
All right.
And if you have any other questions, happy to address them.
I don't think that I do. You addressed some of the notes I had made regarding your brief. So let me throw it back over here to
Sure,
counsel
I'll
on my
start.
right. Do you have anything to say in reply?
Sure, I'll start and,
Okay.
I think Mr. Call's argument really demonstrates the problem here is that there's a number of issues that the DMV is trying to shoehorn into a false advertising case. If this is a case about whether these features are safe, use the word unsafe and talked about accidents and so on, that's not a false advertising case. There are other bodies out there that are investigating that. National, NHTSA and other bodies are out there investigating whether this is a concern, whether these are safe. That's not false. What the media says, not false advertising. I'll note, you talked about media articles. If we start getting into that, you're going to see every media article says, Tesla says their vehicles are not autonomous. Literally, every single one says that. Couldn't be clearer, but that's not what this is about. What legislators say is not what this case is about, right? This case is about the DMV's accusations of false advertising, which say, and this is important, they say not people might be misled to think that vehicles are fully self-driving. That's different. They say people might be misled, and they don't have an allegation that people have been misled, that they might be misled to think that they're autonomous. And autonomous is different than self-driving. Under the definition, a car can drive itself under the supervision of a person ready to take over, and it is not autonomous. And so the words matter here, and this sort of amalgam of things matter. You can't just sort of bring everything together. If the question is what happens when somebody loans out the car to somebody else, that's not advertising at that point. That's a different issue. Right, that's not about a false advertising case. You want to talk about that? Maybe we need to have some different statutes at play. I don't know, but it's not this case.
What about the allegations in paragraph 6 relating specifically to the feature names and to vehicle code section 24011.5? I don't think you focused primarily on the idea of misleading advertising earlier, but I don't think I heard you address anything about this alleged statutory violation regarding the names.
Well, I think there's two issues with that.
Okay.
One is there is a constant, it is a false advertising statute. It is not a sort of in the ether statute. If you actually read the statute, it is about false advertising, and what it says, sort of paraphrasing, is essentially you can't use labels that would lead somebody to think that the vehicle is autonomous. It's really very similar to the allegations otherwise. The difference is sort of because the statute hasn't been dealt with. I think this is probably the first case dealing with it. Is there's a question of whether you can look at those labels by themselves or not. That's a constitutional issue that Mr. Kurtzberg is going to talk about. But where are we talking about them? And I think this is part of the problem is, from a practical perspective, again, what is the DMV's case here? Is it the website? Is it in the vehicle? Is it something else? And if it is what Mr. Call has laid out, which I'm not clear exactly today what it is at that point, then we go into a different world, notice problems. And that's a different issue than we raised, but it's an issue that their opposition and Mr. Call's argument seems to be bringing to the fore of what are we defending against and what are we going to be dealing with? But there's a problem from a false advertising angle with looking at just that statute. I have some other comments, but let me pause on that. So Mr. Kurtzberg can address that point, and then I'll come back on some of the other things that I'll talk about.
I'll start by addressing the 24011.5B and paragraph 6 issue. That is a new statute. It hasn't been interpreted, but the First Amendment really does provide some guidance here. We made our facial challenge. We've made clear we did that to preserve our right to argue it later. So that's why we did it. And we don't want to be accused of not having raised the issue below if we end up in a state court arguing this later. But the reality is the First Amendment makes very clear that you have to look at the speech in full context. So they can't it would not be constitutional to say, well, just the label itself, completely devoid of context, is misleading. And we would suggest that 24011.5B has to be, because of the First Amendment concerns, interpreted in such a way where the label is considered in context. And that is what the cases do. We talked about the butter label case, right? You can't just say, well, the label devoid of any context is somehow misleading. If it is potentially misleading, it has to be judged in context, and all of the First Amendment protections afforded to commercial speech need to be provided. Here, as I think Mr. Newman said, they don't allege that there's been an actual confusion. And the test is whether a reasonable consumer would be confused. And the labels are provided in a context. We've provided that context. The context could not be any clearer that there are disclosures surrounding it that make clear what these features do and don't do. And they don't even dispute that those disclosures get it wrong. Those disclosures are all over the place. And so we would suggest you cannot, because of the First Amendment, look at that in isolation and just say, oh, well, the label somehow devoid of context is problematic. And by the way, it is very problematic just to also address this sort of, do we have notice of what the allegations are? There's a whole section of the argument that was made that I just called it the what about section. What about the videos? What about what the CEO is saying? What about things on the secondary market? That's precisely the problem, and it illustrates precisely why we don't have notice to defend ourselves. They come in, they make arguments about speech where we can't provide the full context, because the first time we're hearing that argument, it wasn't in their brief, it wasn't in their papers, it's not in the accusations. And that is what we are entitled to have notice to defend ourselves. We shouldn't come into court and then have for the first time speculation about, well, what about this issue? What about that issue? And we don't have the context. We can't even point out to Your Honor, well, this statement was made in this context and here's the full disclosures. We cannot proceed in a litigation where we can defend ourselves if there is a constant moving target. It is unfair and it would violate due process. And that's precisely what they're trying to do. They are avoiding trying to look at the issues in full context. I have other points on the First Amendment. I want to say they talked about the fact that in the Caskey case, they say that commercial speech is hardier than other forms of speech because of profit motive. That is true, but the case law does not say that as a result of that, therefore all the First Amendment protections get thrown out and it can't still be chilled. It can be chilled, and in fact, the courts have repeatedly, both the Supreme Court, the Ninth Circuit, the state courts, they describe the protections for commercial speech as rigorous, and they describe the problem of potentially chilling truthful commercial speech as being extremely important. So the fact that Caskey said that commercial speech is maybe hardier because of the profit motive than other forms of speech, like political speech, doesn't mean that commercial speech can't still be chilled. And in fact, the case law says it can be, and that rigorous protections apply. The fact is, they say that also that the touchstone cases was the language that are used are cases that just ban speech, like banning speech about pharmaceutical advertising and things like that. That's not true either. The fact is that commercial speech protections apply not only to commercial speech bans of an entire category of speech, but there is absolutely and can be no dispute that the full commercial speech protections under the rigorous test of intermediate scrutiny that we've described also apply to regulations that burden commercial speech or regulate commercial speech. And if they want a case, if they want to talk about touchstone cases, we cited the In Re RJM case, which is, I think, a commercial speech case that couldn't be clearer that if the information may also be presented in a way that's not deceptive, then the speech cannot be prohibited entirely. Well, that case right there would prohibit a view where there's sort of a view of looking at a label under the new statute in the abstract and devoid of context. The fact of the matter is you have to look at it in context, and if it can be presented in a way where it is not misleading or not deceptive, then it gets full First Amendment protection under the rigorous tests that we've provided. And here, it has been presented in every context that they have told us about. It has been presented very clearly with disclosures that make crystal clear that no one could dispute what they mean. They basically say outright, this is not a fully autonomous vehicle. I mean, it could not be any clearer. And as we've pointed out repeatedly, they're at every stage, every step of the way. We cannot fight against this sort of hypothetical, well, what if this could happen? What if that could happen? If they want to make an allegation that something was false or misleading, we need to know what it is. We need to be able to address the context. And we have done that with these accusations. We have taken the context. There's a lot of citation to cases by our opponents and a lot of talk in the abstract, but not a lot of defending that all the disclosures, no disputing that all the disclosures that we have provided make crystal clear that the truth is the truth, that it is not a fully autonomous vehicle. They say that. I'll last address the issue of judicial notice, which they said that basically they don't contest that the things that we put in the record say what they say, but they contest what they mean to a reasonable consumer. That's not grounds for denying a motion for judicial notice. That is grounds for saying we will grant the motion for judicial notice and then allow each side to argue about the significance of the statements that no one could dispute are what they are. They are perfectly entitled to say, we concede that all those statements are out there, but we think a reasonable consumer could read language that says, current autopilot features require active driver supervision and do not make the vehicle autonomous, or read language that says full driving capability. The currently enabled features require active driver supervision and do not make the vehicle autonomous. They could argue if they want that a reasonable consumer seeing that language would read it and then conclude that it is a fully autonomous vehicle, but they haven't argued that. And the reason they haven't argued it is because they can't really argue it. So what they do is they shift gears and they ask, what if this, what if that? But when we are faced with specific allegations that we have notice of, that gives us a chance to say, here's the full context, we submit no reasonable consumer could conclude that these statements that are being made or the labels that are being provided are being suggesting in any way anything other than the truth. Under the First Amendment, we think that requires you to conclude now at the earliest possible juncture that you would at least make the recommendation that these be dismissed.
Let me just deal with the last issue, which
Yes.
is the procedural side that Mr. Cole talked about.
Mhm.
And he may have misspoken, I think, because there is a case where the hearing officer did make a recommendation of dismissing the accusations. It's the Grant case. Now, in that case, the hearing officer took it under submission and did have the hearing, and ruled on both at the same time. So it's not the case that you can't or you shouldn't rule on the objection. There is an open question, as we said from the beginning, of when and what makes sense. But the whole purpose of 11506A2 is for a respondent to raise objections just like this. This isn't a question of pleading standards of, Mr. Carl's talking about, well, some cases under the federal rules of that's not what we're talking about here. What we're saying is, as drafted, these accusations don't state facts or acts or omission that give rise to the allegations at that point. And so, or the accusation, excuse me. And so we've talked about when is a matter of discretion. And we'll concede that right now. And the reality, though, is in this case, for all of the reasons we've been talking about today, it makes a lot of sense to do this now because this is a matter of law. And these, the question of what should you be looking at? Well, it's very clear. All of the cases, both sides cases, make clear what you should be looking at. You should be looking at the advertisements in context. We provided that context. And so you can, as a matter of law, determine that no reasonable consumer would be misled. And one of the things we haven't talked about that we did submit in the RJN is a couple other cases that have dealt with this very issue. And the reason those are there, obviously, those aren't binding on this, we recognize that. But when a New Mexico federal magistrate judge looks at the exact same things and comes to the conclusion as a matter of law, looking at the exact same advertising with the exact same, pretty much the exact same allegations that that they mislead people, say they're autonomous, reads the same disclosures and said, no, that should be at least persuasive, and it could show, and the reason that it's there is to show, look, this can be ruled on as a matter of law. So there's no dispute that these cases are out there, and that those are appropriate for the court or for you to take a notice of. And as to the sort of context around it, it isn't, again, just the RJN, it's also the incorporated by reference issue. I think that unless you have further questions, we have probably responded to what we need to, but I think it's very important, just again, going back to Mr. Hall's argument, that we focus on what's in the accusations, that these are false advertising statutes, not the sort of amalgam of potential concerns out there about Tesla autopilot, full self-driving capabilities.
All right. I don't have any other questions that I think you can answer for me orally here. I do think that I'm going to go, now that I've heard this discussion, spend some more time with your briefs and your arguments before I issue a written order. But I think that I've heard what I need to hear to be able to understand where each side is coming from and issue that order. I'll probably do it within a week or so. I may not finish drafting an order today because there's a lot to read and think about, but I will do it soon. And if my order is not to grant any of the relief that's requested, I believe our next thing that's on our calendar is a pre-hearing conference in early August, at which we would discuss how to prepare for a hearing. So don't strike that off your calendars right now because I have not sent you any order about such a thing. If at any point as you continue to prepare for this hearing, again, assuming I issue an order that does not recommend what Tesla has asked for, if you have discovery disputes that require our attention, or if you decide that you need to postpone the hearing to allow for discovery or settlement discussions, you can certainly make those requests to us as well. But otherwise, I will, as I said, I will review everything that I've heard today, and I will send you an order in writing. Not today, but soon.
Thank you very much.
Thank you very
Appreciate
much.
it.
I gotta find the right mouse, and I'm gonna stop this recording. So.